This is WZRD Chicago 88.3 FM. And we have with us at WZRD via Zoom, Judge Neil Cohen. Hello, Neil. How are you today?
Very good. How are you doing today?
Very, very well. First of all, Neil, could you tell us a little bit about your legal background and especially what the field of law were you practicing when you were working as as a lawyer for 20 years?
Well, I've been a lawyer since 1976, so that's a little bit more than 20 years. I went to law school in Florida
Mhm.
and came back home. I was raised in Chicago, first in Logan Square and then Rogers Park and then Evanston, where I went to high school and graduated ETHS
Mhm.
in 68. Then I went to American University in DC. And as I say, in Florida, I went to the University of Miami Law School, came here and back home, took the bar, passed it, and became a state's attorney for 11 years, practicing at 26 in California, first in the appeals division. And then I was rose to become a first chair in the trial division at 26 in California, and eventually a supervisor. During that period of time, I was teaching at the Police Academy and also became a teacher at Chicago Kent College of Law in the clinical program, which I did for 7 years, teaching the problems and practice of criminal law, federal and state. And after that, I went to a big law firm on LaSalle Street as head of the white collar criminal practice there called Lord Bissell and Brooke. It's now called Lord Locke and no longer on LaSalle Street. And after 5 years, I started my own practice and went into practice with another person, sharing office space by the name of Alan Ackerman, who is well known as an appellate lawyer. And that's what I did for 19 years, doing trial practice in federal court, state court, and appellate arguments and briefs writing throughout the country. So I applied to become an associate judge. At that time in Cook County, you could apply and you would be reviewed by the sitting circuit court judges. There were about 272 at the time, and they would pass on you. It was a form of merit selection, actually. The judges would take a look at this and at the candidates and make a decision as to whether they should be a judge or not. And fortunately, and gratefully, they found me to be qualified, and I think and I thank them for that. And that was in 2009, and I started. So I've been a judge since 2009, and that was the nature of my practice beforehand. It was trial work, uh, motion practice, criminal, civil, state, and federal. It was very interesting, a lot of fun, but I was more than happy to become a judge.
When you said that 272 judges had to vote whether to let you become an associate judge, how many of the 272 had to vote to approve you before you could become a judge?
Well, there is no answer to that question. It was just it depended on the number of spots that were open for associate judge. In my case, there were 10 spots that were open, and the top 10 vote getters would become an associate judge.
Oh, okay. Why is it that there were 10 spots open? Is it judgeship very sought after? And why would 10 spots be open at that time?
At that time, and let me distinguish that time from this time in a moment, but at that time, there were, as there are now, a distinction between associate judges and circuit court judges. And they would be distinguished by generally the amount of the nature of the work that they would do, but also by the amount of money that they would make. Typically, an associate judge would make $20,000 less. Typically, an associate judge, unless she or he had any particular expertise in an area, would start out in the lower regions of the Circuit Court of Cook County and have to work their way up. That's actually true for beginning circuit court judges now as well, and go through training and become expert in one field or another. So whenever an associate judge had retired, it would open up an associate judge spot. And so they would hold an election after 10 spots became open. And that was the case in my situation. 10 spots had opened up because 10 associate judges had left, and they had to be filled.
I think, is it true that in private practice, you make more money or make more money than being a judge? But what is the draw of being a judge?
The answer to your first part of your question is maybe. It depends. Each person is different. Most of the folks I know of who have become circuit court judges through election or appointment by the Supreme Court, or associate judges by election by the circuit court judges, did in fact make a lot more money than they made as public servants. And the reason for that is, money isn't the end result of everybody's goals and ambition. To me, public service is a way of life, and it's also a way to fully live. I was trained that way by my parents. I was raised that way during the 60s and 70s and 80s. My sister was head of the ACLU in Maine. We've always cared about doing public service and doing good. That's the way, the value system of my family, my tradition, as it is of most, if not all. And it has its own value. But remember, I became a judge after many years in private practice, and I had made my fortune, my money, and I wanted to not worry about that anymore. I didn't have to worry about that anymore, and I had the luxury of dedicating my talents, my mind, my heart, my value system towards adjudicating cases. And that's what I enjoyed doing. And I was happy to do it.
So once you became a judge, did you have any training, or is it that you just had when you were in private practice and you came before a judge, you learned what a judge needed to do during all those years?
Oh, no, there's training for new judges. In fact, I'm involved with new judges training. We're having a meeting this week for the next new judges section that's going to come in. And it's evolved, and it's become broader and more complicated, and more and with deeper dives into specific areas. So the new judges have a vast area of experience that they bring in, but also of the schools, the courses they take that they can draw upon, and also literature that's given to them that they can rely upon when they are learning their craft, so to speak. And as you say, I was an attorney for a long period of time, and I did learn a lot about what it takes to be a judge. I appeared before many judges as a state's attorney and as a private counsel. But no matter how many judges you appear before, it's not the same as being a judge yourself. And you need a number of years as a judge to actually become more expert and reckon with the vast burden of making these decisions. And when I say burden, I don't mean that. I mean responsibility of understanding that you have human beings in front of you, that you have to judge, that you are told to judge and make decisions about their lives. Yes, it's true. They've made decisions about their own lives, which is why they're in front of you. But still, You have to do the right thing for the right reason according to the law and according to equity.
Mhm. So you do feel there is a lot of responsibility on judges' shoulders to adjudicate these lives of human beings before you.
Of course, and you have to understand that every person is different who comes before you and brings in their own network of experiences, uh, events that shaped them, that led them on their path to appear before you at that given moment, whether it's a civil case or a criminal case. You're guided, of course, by the law about the legislature, the people through the legislature advise you what you should be doing and the framework in which you should do it. But still, each person is different, and you have to think about that person and what they've done in any particular case, and what they deserve in terms of justice. And what is just in any given circumstance changes depending upon the person and the set of circumstances before you. So you
Yeah.
have to be aware of that and not as doctrinaire as you think judges are. You have to be more fluid, I think.
Mhm. You mentioned that judges get training. The Illinois Judicial College, is that where the judges get their training?
No, the College of Judicial Education, of which I'm a charter member and have been a member of for the many years it's been in existence, and I was a member of the committee that was involved with judicial education before our Supreme Court started the college. The college gets together. It's about 20 judges of vast experience throughout the state, geographically diverse, racially diverse, religiously diverse, intentionally so, to determine what's the right course to train a judge, how it should be done, in what form, how many courses, over what period of time, uh, and again, who should be the teachers. So that's what the College of Judicial Education is involved with. They're also involved with policy and putting together uh, the literature I referred to before that judges can rely upon from the bench and off the bench to help them make their decisions.
Usually, how long does a judge have to be trained before he could try his first case?
Well, let me take that in two parts. The first part is a judge may be thrown in to a trial rather soon after she or he has been made a judge. It really depends upon the exigencies of what's needed in the court system, in any system throughout the state of Illinois. But your question is a good one because it brings up the idea that um, you never stop being trained. Every case is a form of training for the next case. Every set of cases trains you for your future career. Just like in life, you learn as you go along. And the younger the judge, the less experience they may have, even if they've been an attorney for 20 years, as I was, or more, before they became a judge. It's different when you hit the bench and have to think about evidence and rulings and what's appropriate in any given situation in terms of a ruling. So you never really stop being trained. That's the good thing about life. We hope we evolve as human beings, we evolve as judges as well.
So the College of Judicial Education, do the judges have sit in classes together, or are they paired with mentors to help them individually?
Well, the College of Judicial Education is different from the training courses. The
Mm.
training courses, judges do sit together. I teach a number of those courses, which I'll talk about in a second. And they may be large courses, but also with the new schedule of training, we have brought them down into smaller courses so that the seminars, so that the groups can get together and talk about things themselves with a mentor. In addition, in Cook County, our chief judge, Tim Evans, has started a mentor program apart from the College of Judicial Education and the Administrative Office of the Illinois Courts, which administratively administers, for lack of a better word, all of these judicial education efforts. Our chief judge in Cook County has started a mentorship program. So each new judge has a specific mentor who can advise her or him along the way for the first 3 years of their judicial life.
Mm.
The
I
College
think,
of Judicial Education, as I said, is different from that. The College of Judicial Education is an umbrella organization that dictates policy, talks about it, debates it, thinks about it, reviews the literature from throughout the world, as a matter of fact, not just the country, as to what's going on, what are the what's in the vanguard of new legal issues, and how we should teach the judges. And in fact, every 2 years, every judge, no matter how long you've been a judge, new or old, goes through a training program called EdCon, Educational Conference, which we have in 2 sessions every 2 years to split up the judges throughout the state. And there's about 900 throughout the state. So we all learn together. And in those classes every 2 years, the judges get together and in large groups and small again to discuss all the vanguard issues in civil procedure, substantive civil law, criminal procedure, which is forever changing, thank God, and criminal substance as well.
and so when you say review literature, is it case materials, or is it even general happenings in society, how what society is concerned about?
It depends upon the class. Some classes we review the latest cases that have come down from the Supreme Court of the United States, the Supreme Court of Illinois, the Illinois appellate courts, including a discussion about whether there's a difference of opinion among the different appellate courts in Illinois. And in other courses, we'll do a practicum. We'll talk about and we'll have hypothetical problems, which a teacher, a mentor, either myself or somebody else, will guide the students through to help elicit and bring out the issues that are present in deciding a particular case, whether it be a case of evidence, what is hearsay? In the old way, what is hearsay when you're talking about social media? When you're talking about Zoom, how do you deal with that? When you're talking about TikTok or Facebook, how do the old rules of evidence apply to the new technology? Things like that. And we'll do that in both large groups and then break out into small groups for individual problems, and then share our resolution of those problems with the large group. For instance, some courses are just small seminars to talk about interesting issues and important ones that are coming up through the appellate court and that judges have to be aware of to consider how to resolve the issues that come before them.
Could you give us an example of a current issue that a new issue that these judges would be concerned about in their classes?
Well, as I said, the best one is evidence right now. And how does one, when you're on trial, a lawyer has to be able to lay a foundation for the introduction of evidence. Just because something allegedly occurred doesn't mean you can bring it into court. It must be authenticated. A foundation must be laid as to it actually having occurred, and that the documents you rely upon are authentic and purport to show what they actually show what they purport to show, and actually were in social media. So if someone is charged with a violation of probation because she or he was told not to have any guns as a part of their probation, but there they are. There's a picture of them appearing on Facebook holding a gun of any type. How do you get that into evidence? How do you know that's real? Now with AI, which is the really the most important thing right now, you can change depictions in Facebook, in TikTok, and all the other social media platforms. How do you know what real is? So that's an important one to for the judges to think about and to know the law about, not only in Illinois, but in all the other states, in order to lay a foundation for the introduction of that photo, which purports to put you in possession of a gun, but may or may not be true. Another one is about remote justice. A judge is has to make decisions about credibility. Is it okay for a judge to make decisions about credibility in a trial that's done remotely? Isn't there a distinction between seeing somebody and feeling somebody who's in court sitting right next to you in a witness stand, as opposed to on a screen, a television screen? The answer is yes, there's a difference, but they still allow it in. And it's really up to a judge to make that decision as to how the trial is going to be, remote or not remote. But these are issues, two examples of issues that are ever changing and very present right now in our minds.
There is a lot of knowledge to be absorbed by these student judges. I think that a lot of our students that are listening would want to know, do they do homework? Do they have to take tests? Do they have to prove that they have learned the material?
The answer is yes and no. The no part is that they are going to be judged and graded by appeals and by the appellate court as to whether or not they committed reversible error or error of any kind, or whether their judgment was appropriate and justified by the evidence, if there is an appeal from a particular case. But also, we teach judges to seek out advice if they think that they are unsure about something. We teach judges not to rule right away unless and until they're sure of their judgment, and not to be quick to judge. That's why you may see some judges take some time to reflect upon the evidence that's come before them. Other ways that there are tests is that there's a continual effort in continuing education in Cook County, and I know throughout the state, to teach judges constantly about the sins of latent bias and harassment, and to be able to detect in their own opinions and in their own conduct and in their own actions and in their own prejudices, defects, which they have to overcome. And you can't overcome them until you are authentic enough to admit them. And I don't know a person in the world, certainly no one I've ever met, who doesn't carry in with them their own personal prejudices and biases based on their experience, of course, but that has no place in a courtroom. And so a judge has to continually be educated as to the different ways their bias may come out and affect their verdict. And they need to be aware of that. So we have constant updates in education. I just went through, even with my experience, one on harassment and on personal bias just last week. I found it informative and necessary to have
Mhm.
gone through that.
How has personal bias and harassment changed since you last since in this class? What did you learn?
Oh, this class had to do with the new issues that new to me, the new ways, the new language that one uses to describe gender differences and what they mean and how so one can understand where a person is coming from and not judge them because of it. Uh, uh, you know, there isn't a person I know who doesn't have a first reaction when they meet somebody. They either like them, they don't like them, they have a reaction. But that has no place in the courtroom. And it may be something that is that initial reaction based may be something that is because of a person's gender or skin color or how they present themselves, the clothes they're wearing, what they're saying, how they're talking, etc. One has to cast that aside and just deal with the reality of that person is presenting on their basis, not yours. Otherwise,
When
it's unfair.
when you do research on your cases, such as the Village of LaGrange versus McCook Quarry
Yes.
case, do you base your decision on all the evidence presented by both sides, or do you go deeper and research other facts of the case?
Well, we're not supposed to do our own scientific research and go outside the four corners of the evidence that has been presented.
Mm.
We're not supposed to do that. We are not scientists testing different theories through evidence that has not been presented with us. To do so is, as a matter of appellate court law, reversible error.
Mm.
We're not supposed to go to scenes of a crime, for instance, unless the parties want us to and agree that we should. And then, even then, they have to be there. And in a criminal case, so does the defendant. And it has to be recorded, either or both, with a court reporter or videographer. We're not supposed to become scientists. We're supposed to base our judgment based upon the facts of the case that are presented to us and the expert testimony, if necessary, as it was in LaGrange, that LaGrange versus McCook case, the expert testimony that's given to us. We are not supposed to make those deep dives that you referred to,
So if you wanted to
because
know,
otherwise the parties wouldn't know what we're doing. And they
Mhm.
need to know what we're doing, and we need to be totally uh, uh, observable and above board about what we're considering and how we are considering it.
Right, you need to be transparent.
Transparent's the word, yes.
When you, so if you wanted to know more information, let's say the evidence is presented before you, but you don't understand it. So that is when you would ask questions of whoever is presenting the evidence and ask them to clarify, right?
Maybe yes, maybe no. And let me explain. Um, a judge is not supposed to be a litigant. A judge is not supposed to take the trial into her or his own hands and tell the lawyers what she or he wants or what she or he needs in order to decide the case. Because in that way, a judge is actually acting as an advocate for one side or another. It's true, as you say, I may have many questions that are left unanswered. But a judge is not supposed to take the bull by the horns. Let me explain to you why. Although sometimes I do, and sometimes I certainly do ask questions, and I'm certainly known for asking questions and enjoy it. And I do enjoy learning new things about a case that are presented to me. But it may be, to get back to my point that I wanted to make, it may be that one side, the lawyer for one side or the other, whichever one we're talking about, may know the answer to the question that I would ask, but intentionally decided not to bring up that evidence because it could hurt them or because it could open up a box full of surprises, which they don't want coming back at them from the other side. So me, by asking those questions, has really changed the dynamic of the trial and taken away the control of the trial from the litigants. I'm not supposed to be in control of the trial in that way. And so I have to be very circumspect, very careful about the questions I ask, so as not to infringe on the right of an attorney to try the case the way she or he wants to. Strange, isn't it?
Yes,
But you,
it's very
you
interesting.
probably thought that a judge can do anything a judge wants to do in order to find out what truth is. And I would like to, but that's not actually the way it is, because it infringes and impacts and impedes on the right of a party to have an attorney of his or her own choice try the case in the way he or she wants to. When I first got on the bench, the first question I asked a friend of mine was, am I supposed to be discerning, finding out, and judging what truth is with a capital T or with a little t as it's presented to me? And the answer is always the latter, with a little t as it's presented to me. It often goes to the big T, truth with a big T, a universal truth about the case, but not always. And it's not my role to do that, even though I wish it were. Not in our American system of justice. Interesting, no?
Yes. You served in the Chancery Division since 2011. So what is the role of the Chancery Division?
The Chancery Division starts from the time of Henry VIII and just before that, where where there was a court of equity separate from a court of law. And the Chancery is the chancellor was supposed to do equity regardless of what the law was, or strike that, within the confines of what the law was. And that's what we do in the Chancery Division. We deal with cases that have to do with cases filed against the state government, local government, because there's an allegation that the representatives of the people have gone outside their purview, outside the definition of their office, have taken too much power that has not been delegated to them by the Constitution, by the people. We do injunctions to stop people from hurting one another or injuring a business if there's immediate harm involved. We do business litigation cases, a lot of those, where partnerships want to break up or corporations want to break up. We do a lot of cases dealing with insurance cases where an insurance company files what's called a declaratory action, which means they want us to declare that they don't have to pay off on an insurance policy because the insured, the person who was insured, is not covered in this instance, in any specific instance that's brought before me, because of an exclusion in a policy. We deal with administrative reviews, where a police officer, for instance, has been brought before the police board and has been separated from the force because of allegations that she or he has gone outside the purview of their job, and we have to act as an appellate court on the police board. So that's the kind of cases we deal with.
When you mentioned if a public official went beyond his or her purview, does that also include corruption? Do corruption cases end up before the Chancery Division?
No, if it's a corruption case, if it's a criminal corruption case, it goes before the criminal courts at 26 in California, or we have a two towers of criminal prosecution in the United States. One is the state system. Every state has their own system of criminal justice. And there's the federal system of criminal justice. Typically, cases of dealing with government corruption or allegations of government corruption are tried by the U.S. Attorney's Office at 219 South Dearborn in the federal building there.
Then,
So it's not really corruption. It's just going outside the purview civilly of what, I'll give you an example of what a government official can or should or is told to do by the Constitution. So for instance, a couple of years back when our governor was Pat Quinn, he suspended the legislature's salaries, or tried to, and told Judy Trapinka to not pay them their salaries because they didn't do what he wanted them to do. Well, we have a system of government that's three branches: the judicial, mine, the legislative, which is the legislatures, and the executive, Governor Quinn. So I ruled that he's not king, and we got away from the idea of royalty by moving away from England, and he couldn't suspend, and he had no power to suspend the salaries of the legislature just because they didn't do what he wanted. That's the sort of thing we're talking about. That wasn't corrupt. Governor Quinn thought he could do that, and he was trying to urge the legislators to go his way in a certain legislation. But you can do that by talking to people and try and lobby them. You can't do it by threatening their livelihood and their ability to support their families.
so you're a circuit court judge now, and you are running in an election. Are you running unopposed? Are you were appointed? Are you running to keep your seat? What is this election about?
Well, I was an associate judge for most of the time since 2009. Since 2009, I was an associate judge until 2022, when I was selected by a unanimous vote of the Illinois Supreme Court to become a full circuit court judge. And as I said before, the difference between an associate judge and a full circuit court judge is really just money, how much you get, and also the kind of cases you can try. Although as an associate judge, I was given responsibility to try all sorts of felony cases, criminal, and every case in the civil field. But as a circuit court judge, you also have the ability to become a presiding judge, which I didn't have as an associate judge, and I hope to do someday. Rise to the appellate court, which would be nice, but not necessary for me. And also to vote on certain issues that come before the Circuit Court of Cook County, not the least of which is who's going to become the chief judge of the Circuit Court of Cook County when that position opens up, which it does every 3 years. So it has some benefits to it. Also, you are thought of differently by your peers, your colleagues, as a full circuit court judge as opposed to a associate judge. So when I was offered this by the Supreme Court of Illinois, I accepted it. But it also means that you have to run for office. A full circuit court judge can be appointed, but they eventually have to put their career and their credentials before the people of Cook County, in this case, to vote on them, because we do have a democratic form of government, and that's only right and that's only fair. So that's what I'm doing now. We have a primary coming up in the Democratic Party and the Republican, March 19th, and I've been slated by the Democratic Party to keep my seat as a full circuit court judge. And I do have one opponent running against me.
And the opponent is a Republican?
No, it's a woman who's running in the Democratic primary. She has not been slated, didn't ask for slating by the Democratic Party. and has not been endorsed, as far as I know, by any of the um, bar associations that I put my credentials before. She has put her credentials before them before, as I understand it, I'm not sure, and has been found unqualified or not recommended in the past. This is her third time trying to become a judge. And every association that I've gone before has found me to be recommended, qualified, or highly qualified.
How,
Not all of them have come in yet, and I'm still doing some more. But um, I'm particularly uh, gratified that I've been found to be highly qualified by the Decalogue Society. I've been found to be got the highest recommendation from the Arab American Bar Association, which means a great deal to me, being Jewish. I, in many of my efforts, have tried to create bridges among diverse groups, not the least of which is the Arab American Bar Association. I've been found recommended and qualified by the Cook County Bar Association, which is the Black lawyers, the Women's Bar Association, the Illinois State Bar Association, the Lesbian and Gay Bar Association, the Black Women's Lawyers Association, the Asian American Bar Association, and the Hellenic Bar Association, to name those which have come back. I haven't ever been found unqualified by any association. So I'm gratified and grateful to them for that.
did you ever have to run before, or is this your first election?
I never had to run before. This is my first election, and it's a great, and it's fun, and I'm enjoying it. And I think, as I said, theoretically, philosophically, it's only right that the people uh, judge a person based upon who they are, what they've done. Talk is cheap. Show me what you've done, and I'll know who you are.
How many petition signatures did you have to get?
2,600 for my petition.
And how many did you get, if you're able to tell us?
Uh, over 4,000.
And you're okay, there aren't any challenges to your petitions then?
No, none of them have been challenged.
Tell us a little bit about the Decalogue Society. Are you the president of the Decalogue Society? Because you did receive an award from them.
I did. I'm not the president of the Decalogue Society. I'm a member of it. The Decalogue Society is the oldest association of Jewish lawyers in the history of the United States.
Mhm.
And this is its 90th anniversary year coming up. And they teach you don't have to be Jewish to belong. You don't have to be a man to belong. You don't have to be white to belong. In fact, we've had a black male as president of the Decalogue Society in the past. We currently have a female, Judge Megan Goldish, as president of the Decalogue Society now, and we do good works. We get together to teach lawyers, regardless of your faith or background or gender or sexual identity, what the law is, the latest. It's a lot like what we do with the College of Judicial Education, except this is for lawyers. Lawyers are not trained by the College of Judicial Education, but they are trained by other associations like the Decalogue, like the Illinois State Bar Association, and like the Chicago Bar Association. I'm also a member of the President's Club, which is a newly started association, which is an association of all of the Bar Association presidents, which is just starting now to formulate our agenda and what we're going to do to bring all of the groups together and form bridges among all of the associations. And I happen to be currently the president of the Jewish Judges Association. I'm in my second year right now.
When lawyers join these bar associations, is it for training too? I didn't have any idea that there was a training that was part of being a member.
Uh, the best benefit of belonging to an association is training, is learning. You know, there's a tradition in all in all cultures of learning and knowledge for its own sake, especially in the Decalogue Society, where we're supposed to do justice. We're supposed to learn what justice is, and we're supposed to keep up on what our chosen field is, so we don't commit malpractice, but more, so we can do the right thing in the right way, at the right time, for the right reason. And as lawyers, as a lawyer, I had to do that, and that's what the Decalogue Society does. Mostly, it's its primary reason. It's also a good idea to have a presence for the Jewish lawyers and those who wish to associate with us and be members with us, especially in these days of greater anti-Semitism and greater attempts by certain groups and people to divide us from one another. The Decalogue Society works really hard to build bridges with other associations, as does the Jewish Judges Association. It's very important. In fact, it's our cornerstone that we are not alone and we are here for others. We're here for you.
Well, you did mention building bridges many times between associations. If those bridges need to be built, what is dividing the associations?
Well, there's a normal, Chicago is a Chicago is a city of ethnic neighborhoods. And there's a reason for that. And that's because when folks came to the country, they came where others like themselves had settled. And they normally just settled into their own little villages within the city. That's fine. And that's where people feel comfortable, can be nurtured without fear of violence against them of all sorts, psychological, emotional, physical. But when you live in our world now, where there's so much violence and so much antipathy against people just because of who they are or who they love or what they want to read or what they want to believe or what they like to eat, it's very important to build bridges among these groups so that groups who are affected by that know that they're not alone and that we stand shoulder to shoulder with them, just as the Jewish people stood shoulder to shoulder with Dr. King when he was crossing the Raymond Pettis Bridge in Selma. And my wife's family's rabbi spoke just before Dr. King in 1963 at the March on Washington. And the Jewish people have a tradition of reaching out and being there for those in need, having suffered, as history shows, so much ourselves from
Yes.
from prejudice. It's part of our core belief.
In 2022, what you received from the Decalogue Society, the Distinguished Service Award. What kind of service did you do to receive that award?
Well, you'd have to ask them. It's not for me to toot my own horn, but I'd like to think that my efforts on the executive committee of the Illinois Supreme Court and the strategic impact committee of the Illinois Supreme Court and working on training young judges and teaching lawyers how to become judges and how to navigate through the system and building bridges among associations and helping those who are incarcerated to find a pathway towards rehabilitation when they get out were factors that led to my getting the award. I don't kid myself. There are others who do that and more than I have, but they chose me, and I'm glad that they did, and I'm glad that I could stand as a model for others to do the same thing and speak for them and remind the folks who gave me the award that I'm just one of many who are continuing to do that.
Northeastern Illinois University is doing a lot to help people who are incarcerated to learn while they're in prison, and then have more opportunities when they are when they return to society. So when you spoke about you're helping the incarcerated, helping the incarcerated, and if the incarcerated heard of that and want to know more about that or reach out to whatever you're doing, how would they go about that?
Well, what I'm doing right now is I'm teaching a course on impact incarceration to young judges. And the theory behind that is that a judge a judge usually sits higher than those who she or he is judging. And that has its own impact, not necessarily the best. But a judge should be looking, when someone comes before a criminal judge who's just been arrested, it seems to me, it may very well be they've been arrested illegally, unlawfully, and without probable cause. And they are presumed to be innocent. But it may very well be that the criminal justice system has found someone who's acted in a certain way, which is telling society he needs help or she needs help. And when they come before a judge at the first instance, that's the time you should start rehabilitating someone or putting them in efforts towards rehabilitation. Not when they get out 20 years later or 10 years later or 5 years later. They're only going to learn bad stuff in the jail. They need to be taken under the wing of a judge or the system to start realizing that there's an impact to being in the system and working on that. So what we can do is to start rehabilitation through psychological courses, training, personal and in groups. You can talk about getting GEDs, educating them. If they have to go to prison, give them a way of using their time to learn a craft or an art so that they can be employable when they get out. Getting them work papers, a driver's license, an identification card, so that they're ready to go when they walk out of those, out of that prison. I've been working, and when I teach this course, I bring people who have been let out of jail, who've been in prison for murder, for violent crimes, for theft, for guns, so that new judges can learn their experience vicariously and listen to them and understand that these are human beings. They're not just numbers. It's not just someone who committed an armed robbery. It may be someone who committed an armed robbery, but it doesn't make them an armed robber for life. We're not locking them up and throwing away the key. I work with and bring Arnie Duncan's Chicago Cred to speak on the same panel, and they talk about their programs to help these folks. And Arnie Duncan has put together an amazing organization that does meet them at the prison door and takes them under their wing and tries to get mentors for them and jobs, et cetera, and work on it. And so what I helped to do was I introduced the IDOC, Illinois Department of Corrections, through these courses to Arnie Duncan's folks, and they're now working together on figuring out what these folks need to learn and do before they get out, while they're incarcerated, if they are, so that they're ready to become an important part of society and have a family and be a good role model for their kids. That's what I'm doing right now with regard to that. Let me give you just one little anecdote about that. I've recently been with the Legal Services Corporation in the Gila River Reservation in Arizona. And any Indian reservation is federally under federal control in part, but not totally. Each reservation, each tribe has its own system of justice. And when I talked to the chief of the tribe of the Gila River about these things, about criminal justice, he said, when we see a member of our tribe committing a crime, we feel as if we're all responsible for what he or she did. It affects us all. And we all take that person, we all failed that person in some way. And we all try to engage that person in healing, spiritual, psychological, and tribal healing. And I think that's what we need to do in Chicago. I think we need to think of ourselves not as separate tribes, separate gangs all over the city, separate ethnicities, but we're all going to rise and fall together. We're either going to do it together or we may be doomed. So let's start healing each other and working towards healing members of all ethnic and all sexual and all gender and all diverse communities. Let's think of each other as brothers, as we're all taught.
Judge Neil Cohen, there is so much that we would still like to discuss with you, but let's save that for another interview. Thank you so much for joining us on WZRD Chicago 88.3 FM today.
Thank you. Glad to be here.